Just trust me. Just trust me. We're live. All righty. And
1, 2, 3, 4.
There's nothing more thrilling than nailing an insurance company.
And the truth shall set you free!
I want the truth! You can't handle the truth!
Great moments are born from great opportunity.
All right. Welcome, everyone, back to an episode of the On Justice podcast. Actually, this is our first live edition, so for those of you tuning in live to the podcast, welcome. We have, as always, my very talented partner, Fischer Redavid, with me as well here on the podcast. And we're excited to talk about the recent case. I don't know if anybody's heard about it. It's the McDonald's hot chicken nugget case that is spreading across the nation and the globe, creating a really polarizing viewpoint on what's appropriate, what should have happened, what didn't happen, without many people really knowing any of the facts of the case from the small snippet of what the media portrayed in the public. So we're gonna talk about that a little bit.
Yeah, I mean, we won twice in legal courts. Today we're going to try and earn some ground back in the court of public opinion. The only member of the trial team that is not with us today, but I want to give her shout out, is Keela Smith. She tried phase 2 with us, but is not joining us on the podcast today. But the three of us, her, John, and I, we tried the case in Broward County, Florida Circuit Court. Judge David Hames presided, and we got the verdict on Wednesday of this week. It was a 3-day trial. So I think it's important, even though everyone's talking about this most recent verdict, to step back and think about how we got here. I want to kind of educate the people out there on the legal process generally in Florida, how it works, and then more specifically in this case, how it actually unfolded. So although this was one personal injury lawsuit on behalf of a minor child who was burned by chicken McNuggets, the lawsuit was bifurcated for purposes of trial, meaning it was split into 2 equal phases. Phase 1, it was determined by the court, would only deal with the issues of liability, meaning whether or not the franchisee and or corporate McDonald's was responsible in any way legally for what happened to Olivia, the minor plaintiff. And then if so, meaning if we prove that one or both defendants were liable, then the court gave us permission to have a whole second trial with a new jury to determine the extent of Olivia's damages. So we went to trial in phase 1 on liability. That was in May. So we showed up to a courthouse in Broward County, and a bunch of members of the community came in as prospective jurors. John, do you remember how many prospective jurors we had for phase 1?
I think we got 30 in the first phase. That's what we had in the first phase, I believe.
So in Florida, jury selection requires that ultimately at least 6 people are selected and sworn to serve as jurors. We typically get 7. So that we have an alternate in case somebody gets sick or some emergency happens and somebody has to leave mid-trial. So that's what we did in May. We impaneled a jury of 7 people. Ultimately, 6 decided it. And for those who are listening outside of Florida, or even if you're in Florida and you're uncertain or unfamiliar of how the legal process works, you need unanimous verdicts in Florida. So all 6 jurors have to agree on the outcome. So when we went to trial in May, we were bringing claims against Upchurch Foods Incorporated. That is a Florida corporation. It operates 40 different McDonald's restaurants throughout South Florida. We had various theories of liability, meaning we were alleging that they were responsible for what happened for any number of reasons. And the law allows you to plead alternative theories. So, for example, you could say you're negligent for failing to warn someone verbally. You could say you're negligent for packaging the food too quickly, preparing the food unreasonably, any number of things. So we pled a variety of theories against Upchurch. But we also had theories of liability against McDonald's USA LLC, which is really the formal corporate entity for what everyone would refer to globally as McDonald's. It's the large corporation. Before we ever got to trial in phase 1 in May, both Upchurch Foods and McDonald's had categorically denied any wrongdoing. This was not a circumstance where liability was admitted or conceded. It was hotly contested for years. And John, maybe you can explain how, before we even got to get to trial in May, what it's like to go into a trial knowing that the only thing you have to do is convince jurors that one or both defendants is liable. It's a pretty polarizing case, so you have to tread lightly.
So yeah, I think it was, it's very interesting to have a bifurcated trial. This actually was our first bifurcated trial, meaning liability was the only thing we were deciding, damages to come if we win on liability. And I think that, I used to think that bifurcation was a bad thing, right? And the reason is because if there's a lot of bad misconduct on behalf of the defendant, that jury gets to hear that misconduct. They get to see how they respond to that. And if they're very dismissive of the claims, which they were, then they could, not necessarily use it against them in the damages phase, but they are going to use it against them in the damages phase. Really not a punishment, but a recognition that, okay, they said they were responsible. We don't believe that. That's bullshit. And, we think that they're saying the same thing when they're saying they're not hurt. So, but when you came in, it kind of changed who I look for as an ideal juror. I didn't have to worry about the damages questions, like people that may be opposed to large verdict awards, non-economic damages. They hate all personal injury lawyers. Like, we looked at people that talked about, personal responsibility, community responsibility, corporate responsibility, and looked at all of those things, and could say, what, I can sit here and decide what's right, what's wrong. And I think I need to make this clear for everyone, because there's this misconception. Everyone's like, oh, it's the mom's fault, it's the mom's fault, it's the mom's fault. McDonald's USA and Upchurch Foods did not claim it was mom's fault in the trial. They did not raise any negligence on behalf of the mother. They did not say that they did anything wrong. Okay, so that wasn't an issue, because it's really not an issue. And when you understand the facts of the case, what the mom did in terms of giving a Happy Meal to a child, basically a product that, in the case, everyone agreed to was intended for a child, directed towards a child, that they're the end user customer, her handing it to them was not unreasonable, and nothing was wrong with that. And, despite every single person I've read in the comments that, like, oh, I check every single food ever before it ever goes out to my kid, whether or not that's actually true, I don't think that's true.
But that's not the legal standard, right? The standard is what a reasonable person would do. And to clarify just one point, when McDonald's and Upchurch were first forced to defend the lawsuit, they did allege, as one of their variety of defenses, that the mom was at fault in part.
Right.
So for years in discovery and pretrial motions, that was on the table. But on the eve of trial in phase one back in May, strategically, they decided to stipulate mom's not at fault. I think it was a good decision for them. I don't think the verdict against them in phase one would have been any different had they blamed mom. In fact, I think we still would have won, and maybe even with a faster deliberation, because through the lens rather of reasonableness, this question is not whether you, as an individual person, unique to yourself in your own idiosyncratic ways, checks food for its temperature before you hand it to a child. The question is whether it was unreasonable for Felena to simply grab the Happy Meal box from the window and hand it back to her children. And if you really think about it through the lens of reasonableness, every parent does that, or I should say the overwhelming majority of parents do that. And if that's what they do, that makes it reasonable. And I think that's why both defendants decided to not make that an issue, at least formally. But John, maybe you could talk a little bit going back to phase one. Even though the defense stipulated mom wasn't at fault, it certainly felt like they were trying to suggest, even if subtly, to the jury that she was.
Yeah, I think that, they didn't want to come out and explicitly say, mom's at fault and have to put her name on the verdict form. And then they have the burden to prove, what she did by handing those chicken nuggets, like, she should have known those nuggets were going to burn her kids. I think that defeats the purpose of them saying, we didn't do anything wrong, it's not foreseeable. They would have had to say the mom should have foreseen that handing it to the nuggets, it would have burned her child. And I think that's why they had to tactically or strategically remove that issue from the jury, but they still kind of argued it. Like, they wanted to show the video. In jury selection, the attorneys for McDonald's asked, well, how many of you have handed your food in a Happy Meal to a child without at least looking it up and checking to see how hot it is? I mean, those were the kind of questions they were asking. And surprisingly, based upon the comments that after the fact, nearly every single person was like, I don't check. I trust that the McDonald's company is going to hand it and have it safe, so I don't check. And here's what's interesting. During trial, a member of our trial team House in La France, a little shout out, found a YouTube advertisement from McDu's. Now, McDonald's is an international corporation. So McDu's is what they call it in the Philippines, like Mickey D's here in the United States. And they had an advertisement of a family, mom and dad, pulling into a drive-through, ordering a Happy Meal, and then giving it back to a child sitting in a car seat and then pulling out and eating chicken nuggets in her car seat. Why is that important? Well, the issue was whether or not it was foreseeable that a child would eat a chicken nugget with their hands in the car seat and potentially drop it. And here they have advertisements showing precisely the setup for our case. And, the question was, is it foreseeable that a kid could drop it? And the corporate representative for McDonald's in trial, I remember this because I was examining him, and I said, look, like kids, when they grab something that's hot, they could drop it. And he was like, well, yeah, they're going to put it back into the box. I was like, do you have kids?
Yeah.
What kid do you have? No, that's like, oh my God, it's hot, and then puts it back. No, they just drop it. 4 years old, they're going to be like, ow, and drop it. So I think that was very helpful to combat the idea that mom did something wrong, even implicitly. And
the jury rejected it.
Yeah.
Like ultimately, that verdict from phase one, to me, putting aside like from a technicality standpoint, what theory did the jury find most persuasive? Ultimately, what it did is it rejected the notion that mom was at fault for sure, and it clarified that both the franchisee and McDonald's corporate have shared responsibility here. We did a full podcast after the May trial on the liability phase one, so I don't want to rehash everything. And maybe Justin, you could put a link in the show notes, to wherever it is on Spotify or YouTube, because we did a full-blown deep dive there. But this is now relevant to the phase two trial we just had here in July of 2023, which is that after phase one, the media started to report that verdict as a split one. Right. They literally called it a split verdict, which suggests, I think wrongly, although I don't think there's any malice here, it's just reporters doing their best at their level of awareness. It suggested that the jurors somehow split the baby and decided, well, maybe they're at fault a little bit, but not a lot. That's not a thing. It was an all or nothing. It was, here's all the evidence and here's all the theories. Jury, if you think the greater weight of the evidence supports liability for any number of theories, one or more, check yes. And they did check yes to one theory for each defendant, which is another way of saying the jury found with certainty both defendants are responsible. And when it comes down to McDonald's, this is a product at the end of the day, and the theory against McDonald's that the jury in phase one found was a failure to warn, like a strict liability failure to warn. And when you're thinking through that, ask yourself, well, why would the jury have found that in phase one? It's easy if you're sitting back and you don't know the details of the case to say everybody wants hot food. That wasn't the evidence in this case. The evidence here was McDonald's basically conceding through its experts and corporate representative that they are knowingly preparing the nuggets and then serving them at temperatures capable of burning children with second-degree burns. And so the question was, well, if you're doing that, even if you're doing it for legitimate reasons, you want them crispy, you want them feeling fresh, tasting, whatever, fine. But if you know you have to cook them at a temperature that can burn children, then shouldn't you warn? Because parents, conversely, should not reasonably expect that when you hand them a Happy Meal box, the contents of it could disfigure their children within seconds of touching it. And that's what the jury understood. So go back, watch that other episode. I encourage you to. And if you still have questions, give a shout out to our firm or Justin, and we can answer them through social media. But let's switch gears and flash forward in time. So we win phase one in May. The judge says now you're entitled to phase two, which is a completely separate jury trial. You have to find new jurors. So you got to bring a different prospective jurors. You got to find a new 6, maybe 7 to pick and present all the evidence about Olivia's damages. So after phase one, we go to phase two. Now there's some new evidentiary issues in the case. Why? And John, maybe you can talk about, we decided to waive entitlement to economic damages and ask the jury only to consider non-economic. Maybe you can educate our audience out here as to the difference between the two.
Sure. So when you're thinking of damages in a trial, like a personal injury matter, there's really, well, I'd say there's 2 categories of damage, right? Economic losses. Some lawyers refer to those as paycheck losses. You've got medical bills and lost wages, right? And that would be in the past, and then those to be incurred in the future. Then you've got the non-economic damages, and non-economic is the more, I don't know, I would say tangential, but it's not something that you can say here's a hard defined number. That's the physical pain and suffering, emotional pain and suffering, mental anguish, inconvenience, loss of the enjoyment of life, humiliation, fear, aggravation of existing disease like disability, disfigurement, impairment. Like all of these things are non-economics. Now, because the medical bills, obviously, if they're a small monetary amount, like we tend to waive the medical bills, so we don't make a claim for economic damages, and because it's a low number, and when you're lawyers and you're trying to have significant recovery, if they have a low number in the case, sometimes jurors can latch onto that. They call that a low anchor, and defendants do that all the time. They want to put in a low anchor to keep the juries thinking of low numbers.
And it's hard to, even if, like, another way of thinking this is, it's hard for jurors from a psychological standpoint to say, I want to give this person, let's say, $100,000 for non-economic, those intangible things John talked about, pain, suffering, whatever. But I'm looking at her economic damages, the medical bills, for example, not in this case, but in another case, let's say they're only $1,000. It's hard for juries to say, well, it's only $1,000 for medical bills, but wait, now I want to give 100 times that for pain and suffering, right? Even if they know the greater weight of the evidence supports it, psychologically, there's an impediment there. And so jurors sometimes have a habit to award less than they otherwise might, which isn't fair in our view, but it's human nature. So one of the ways we can mitigate the risk of that, like John said, is strategically to talk with our clients and say, look, we understand there are some medical expenses here, but we feel like if we don't talk about those at trial, if we waive entitlement to ask for reimbursement of those from the jury and only ask the jury to focus on the human losses, those intangible non-economics, we stand a greater chance of them actually giving you full and fair justice for that. And that's typically where the substantial recovery lies. So this was another case, it wasn't the first time we did it, but where we, with the client's consent, strategically waived past and future economic damages to focus the jury only on non-economic. Now, it's good from a legal strategy, but conceptually it has a lot of complications because, that John can attest to, more often than not, jurors don't have an issue assigning fault or blame. They can do that with confidence. More often than not, jurors can provide reimbursement of medical expenses or even give you an amount of money that they think will reasonably cover your future medical expenses. Somehow that's easier to do. When it comes down to assigning a value to pain and suffering, it feels arbitrary to many people. The most common question we get in voir dire jury selection is, how am I supposed to do that? Because the law in Florida, and it should say this, is there's no exact formula. There's no specific way to get there. You just have to do what you feel is right. And that becomes very uncomfortable for some jurors because everybody knows money doesn't make pain go away. And they can't buy you a time machine with it either. But the flip side of that coin is, if we don't give people money, what are we supposed to give them? John talked about that. So let's actually get into jury selection from phase 2 of the McDonald's hot nugget case. John did jury selection. Let me just tee it up for him a little bit. So in this phase, the judge recognized we had filed a motion asking for a larger number of prospective jurors than usual. In phase 1, he didn't give us that relief, but it was okay. In phase 2, he recognized, all right, you've won phase 1. Not only are people drawing analogies to the hot coffee case from the 90s, but now even our case in phase 1 made national and international news, which means a lot of people read about it, drew conclusions, had strong personal feelings about it. Why does that matter? It increases the likelihood that people were going to show up from Broward County and say, I have a bias one way or the other already about this case, and there's no way I could be fair. So instead of bringing 25 or 30 jurors, Judge Hames, and thank you for that, he brought 50 prospective jurors. So a substantial increase from what we otherwise might have had. Why does that matter? It increases the likelihood that from that 50, we'll be able to find 6 or 7 that, at least for all intents and purposes, could be fair and impartial. So 50 people showed up on Monday. All we did on Monday was the court, us through John, and the defense through lead defense counsel took turns asking questions of these 50 people on a variety of subjects to try and elicit responses to decide whether or not we felt like collectively they could be fair and impartial. And if you're wondering if we needed 50, the answer is yes. I don't remember exactly, but I think it took us into the 40s before we finally had a jury picked. And that's another way of saying, if the judge had only brought 25 or 30 like usual, we would have busted the panel, which is just a legal way of saying had to start all over again. There wouldn't have been a jury to pick from. So, John, can you kind of take us through your jury selection, how you felt in the moment? We did have the benefit of a jury consultant. I want to give a shout out to Jury X. We use them often. And the consultant that we use most often is Mary Sheedy. She was phenomenal this time, as she has been in the past.
Yeah, I mean, jury selection is, I think fundamentally the most important part of the jury trial, because if you're starting out with, and you don't need jurors that are on your side, right? You don't need jurors that are going to be favoring me over the defense. What you don't want is the ones that have all the negative bias against the plaintiff and really are in favor of the defense. So we had to root out a lot of individuals that were like there was going to be press involved in the case. I think there were a few jurors that had indicated they heard about the trial.
But less than I thought. I think, if memory serves, only 5 or 6 people admitted to having seen or read media coverage of phase 1. I thought there would be at least half the panel, but there wasn't as much as I thought.
Yeah, there was only.
Did you think that some people were hiding though and not being completely honest, or did you think that was an accurate representation?
It's hard to say. It's like, who wants to be the sleeper agent? Like, I want to blow this case up. And like, I honestly, I don't like to think that jurors would do that. I like to think that once you start the process that they're open and honest type. I talk about brutal honesty in the beginning and all this, and I'm brutally honest with them. So I think that just really trying to find the individuals that can be fair and open-minded. And yeah, of the people that had heard about the case before, everyone was like, this mom is stupid. It's her fault.
One of the jurors, right?
Yeah, right in front of my client's face. Like, this is all her fault. Like, you're gone. Like, and we got rid of all those jurors. And so we went through, and I mean, look, we had a tough panel. We had a tough panel, and we had a lot of people that had very negative feelings about personal injury lawsuits, very negative feelings towards non-economic damages, very negative feelings towards a variety of subjects. One of the things I wasn't allowed to really get into, which I disagree with the ruling of the court, but wasn't allowed to talk to them about big numbers. Like, look, you've seen these verdicts for $30 million. If the evidence would support an award of $30 million. Based upon your negative feeling, like, could you sign your name to that? And you got to know. And some jurors are like, I don't care what the evidence is. I'm never putting a valuation that high. I'm never signing my name. And I wasn't allowed to do that. And
a lot of people let me just say this. A lot of people hear you say that, and I fear that without like some legal training, even lawyers who maybe don't try cases might assume, but really you're just trying to find people who would be favorable and give you big numbers. No. That's not the purpose of the question. It never was. And that's why I think John said we disagreed with how the court ruled, although we respected it and adhered to it. The reason you asked that question is what you're really asking is this. Even if all the evidence in a case, the greater weight of the evidence, the greater weight of the evidence supports a verdict of 30 million or 50 million or 100 million, pick a number out of a hat, it, which means the law requires you to sign your name to that verdict. Would you nevertheless not do it for some other reason, i.e. personal prejudice, bias, or pre-existing beliefs that you can't set aside? So it's really another way of saying you can't follow the law. But of course, if you just said, raise your hand if you won't follow the law, no one would raise their hand. Everybody, and it should be this way, everybody believes they can be fair, believes they can follow the law. So the purpose of John's question was to give them specific examples, like a hypothetical, where they would then reveal perhaps an inherent bias that they didn't even know they had.
Yeah, and what I thought was most interesting, we actually had a member of the jury and the panel who was like Upchurch Foods, an owner operator of McDonald's franchises. I think he may have said.
I won't use his name, but number 18, prospective juror number 18.
Yeah.
Right.
And he was like, I know Mr. Upchurch. I've known him for 20 years. All this kind of stuff. And we were like, look, we moved to exclude him for cause. And when you have a cause challenge, for those of you who aren't lawyers or don't try cases, you're basically saying, look, I have a reasonable doubt as to whether or not this juror can be fair and impartial based upon X, Y, and Z. And we said, like, look, this guy has known him for 20 years. He even told me he might come into his mind, like, he's going to try to be fair, but it might come into his mind, like, these are people he works with. He has to answer to McDonald's.
Didn't he say him and his wife owned and operated 4 McDonald's in Fort Lauderdale too?
I think so. I think it was 4. But the opposing party, i.e. McDonald's, was like, we object to that. Like, he can be fair. And, and I think to the judge's credit, he kind of was like, are you kidding me? Like, you, McDonald's, think that your employee, basically the same franchisee or another franchisee like Upchurch, and who knew Upchurch, is gonna be the right juror for this case. He's like, so tell me if he was like, he said, so if it was the plaintiff's next door neighbor and they were best friends for 20 years and grew them up, you're gonna say that that's gonna be fair and you're not gonna be jumping up and down about that? And they were just like, well, we think he can be fair. And I think the judge is like, oh no, he's out. And I think that if you're going to practice, like, you got to be like, I had somebody that was like, I'm going to be too favorable because it's going to be a child, and I'm going to be biased because I got our client had a developmental disorder. And they're like, my niece has that, and I'm going to be biased against the defense. And you know what I said? She's got to go. I mean, that's what you do. You don't try to get in people that are, and that's what they're trying to do. And I think the judge, to his credit, really was not having that. So that kind of stuck out in my mind from jury selection. But overall, I think we got the best jury we could have gotten out of there.
We exhausted. Correct me if I'm wrong. I think So in Florida, let me step back for a minute. John just talked about cause challenges. Those are unlimited. Any party at any time can raise a cause challenge, which, as John said, is just saying, here's something that this person said or did that gives us a reasonable doubt as to his or her ability to be fair and impartial. You can raise any number of those. Then you have peremptory challenges, not preempt, but peremptory challenges. Each side only has 3. We exhausted our 3, and those are challenges you can use for basically any reason, as long as it's not pretextual and you're just trying to strike, for example, all women or all black people or any number of a protected class. The purpose is supposed to be fair, but just to say, I don't know, I just don't have a good feeling. Each side gets 3. We exhausted all 3 and actually had to ask the court for permission to get a 4th, which he gave. And thank you, Judge Haynes, for doing that. I think it was a correct legal basis to do it. He used his discretion. So we had to use not only all 3, but even an additional one. But ultimately, to John's point, we did select 7 people, one of which was an alternate, but 7 people total, which we felt like collectively comprised, the most fair and impartial people that we could have decide this case. But so that was jury selection. That took all day Monday. Then after we pick a jury, they go home. This was like maybe 4:30 p.m. And the judge took up what's called motions in limine. So these are pretrial motions that either side can file. And they basically foreshadow to the trial court, hey, here's something that's going to come up, or we think it will come up in the evidence, or an argument we anticipate the other side making. I'd like you to give us a ruling now. You don't do this for every last thing on earth, because some things are just best left to happen contemporaneously in trial. And you don't want to burden the court. But you have to do it for things that could cause a mistrial, for example, or things you need some clarification on so you know how to present your own case when trial starts. So we did that. And even though this, we're not going to talk about all the issues, but one of the things that came up was we had waived all economic damages, which we talked about. We're not asking for money for past medical bills or future. The defense agreed that because we waived past medical bills, they wouldn't talk about the value of those. But they disagreed by saying, well, even though we're not asking for money for future medical care, they nevertheless wanted to inject into trial that they believed the cost of a future scar revision surgery was $4,700. Now, step back. Why did they want to do that? And I don't blame them for wanting to. They wanted to do it from an advocacy standpoint to give the jury what? A low anchor. So that when the jury heard us talking about millions, they would have a medical bill in front of them that said $4,700. And psychologically, I think the defense hoped it would have an impact. We argued against it, and I believe in my heart still today that the judge got it wrong because he allowed them to introduce it. John argued this issue for us, and what John basically said is they're trying to give the jury low anchor, but what they're really telling you, judges, this goes to the feasibility of whether or not she'll get this future surgery. The defense had raised what's called the mitigation of damages defense. It's an affirmative defense that basically says we shouldn't be responsible for certain damages if the only reason they're going to be there is because you chose not to get care that you should have got. That's basically what it means. Yeah. But the defense knew that the only care at issue in the future was surgery, and that this 8-year-old child had never been told to get it since, from 4, 5, 6, 7, 8 years old, and was told in the medical records, if she gets it ever, it won't be until into her adolescence. So it was very speculative to suggest to the court, I thought, that this was something she must get and wouldn't. Nevertheless, the court disagreed, even though John said what they're really trying to do also is backdoor in the relative wealth of the parties. So in Florida, the jury is not to consider the wealth of the parties. And think about it, it's a fundamental fairness thing. It shouldn't be fair to McDonald's if we could go to trial and say they make $5 billion a year. And that the reason it's not fair is because then the jury will just give a ton of money thinking they can afford it. But the flip side of that coin is you shouldn't inject the relative, middle class or low class or above middle class. It doesn't matter how much money the plaintiffs are making. That's not probative of their damages. And so I think the court got it wrong by letting it in, but he did let it in, and so we had to deal with that starting in opening statements. Opening statements began on Tuesday, and Tuesday was a really big day for us because we started opening statements first thing Tuesday morning, and we went all the way through. We rested our case, the defense called witnesses, and then ultimately they basically rested their case. Very unusual scenario. John, maybe you could talk, like in the average case, even a short one, it's usually like 3-4 days before both sides rest. This was a one and done.
Yeah, I mean, look, Joe Freed talks about the speed trial, where he's in a day and a half able to get, like 14 witnesses and 6 experts. We got through, basically 4 witnesses in the day, and that was it. I mean, that was the case. And I think because liability is done as just damages, it kind of really short tracks the presentation of evidence. So we called mom to testify first, then we called our burn expert, which was Dr. Joshua Carson, which, I've seen a lot of, I don't know, I've tried 25 cases now. I've seen a lot of experts testify at trial, and this was really one of the best experts I've seen in terms of the way he presented and the way he connected with the jury, the way he dealt with like impeachment. I mean, he seemed like an average guy that's a genius, if that makes any sense. He was like, that he was swiveling in his chair, and usually I don't like that because I'm like, you look like you're not honest, but the way he was so smart and so responsive, and even with the defense, and kind of broke things down for the jury and really made it simple. I think I was really impressed. And this was we had him on another case. We had met him because he was the former director of the burn clinic there in Gainesville at UF Shands. And we had him on a case in the Gainesville area. He has since moved to Chicago, and I think he's at Loyola, and he's the burn director. I think he's one of the main, if not the top, burn doctor in all of the state of Illinois. And, we kept in touch and said, listen, we've got this case. We've got this young girl. Like, can you come down? And, he did it, and he handled it well. And so we broke up mom and dad with him. He explained a lot. He was the only burn doctor in the case. The defense went out and hired like a local plastic surgeon. And I'm going to let Jordan talk to you about the plastic surgeon in terms of how the defense didn't give them all the records, didn't have them all the photo. Like, he was learning about things for the first time in trial, which is never good for an expert. Like, they should know everything. You should. And we broke it up, and then dad testified, and we rested. And
that was it, though. 3 witnesses for us.
And we were done. It's like 3:30. We called the defense doctor, or they did. Jordan did cross-examination. And, that was the case, and that was something that, it's never one day, it's usually opening statements, case the next day, then maybe we'll closing on Thursday, which I think we ended up a little bit like that in liability. And I think if all the cases were together, it'll take longer, but having them separated really made it a short trial.
Yeah. And I think the jury's verdict is only reflective of the evidence, and they're applying the evidence to the law. It doesn't reflect expedience or gratefulness for us getting it done so quick. But if you step back, and for the lawyers out there, those who try cases or aspire to try cases, John mentioned in passing Joe Freed's speed trial method. I think he's kind of pioneering it, but it's something that you can make your own. Have some respect for the jurors' time. Lawyers like to talk, especially those lawyers who try cases in court. I get it. I'm a victim of doing that myself, but jurors are already being massively inconvenienced. They're away from their family. They're away from their jobs. No matter how focused they are, they're thinking about things going on in their own life. So don't prolong trial needlessly by doing a 2-hour direct examination when 20 minutes will suffice. Don't do a 4-hour cross-examination when 40 minutes will suffice. And jurors pick up on that, I believe, especially if you're the one moving quickly, not missing anything, but moving quickly, and the other side is dragging things out. They may not pick it up the first examination, but after 2, 3, 4, 5 witnesses, the jury starts to think, hey, one side is on the ball and moving this thing forward. The other side is just talking. And I feel like this is just a personal belief that from an advocacy standpoint, it's far more persuasive when you can be in and out quickly than it is when you're just talking for the sake of it. So we did opening statements. This is the first time where the defense learned that one of the arguments we intended to make was that having Olivia subjected to 2 separate compulsory medical examinations, we believed entitled her to recover additional money. So let's hit the pause button here and let me just step back and bird's eye view this thing. In any personal injury case in the state of Florida, the defense asks the court basically for permission to conduct what's called a compulsory medical examination, or CME for short. The Florida Rule of Civil Procedure is 1.360, so there is a rule of procedure that exists that gives the court the discretion to grant it. Now, as a matter of common practice, in like 99% of personal injury cases I've handled in Florida, when the defense just asks us, hey, can you coordinate your client to be available for a CME, we do it. So although the law doesn't say they're entitled to it as a matter of law, they have to show good cause. As a courtesy, we almost always just say yes. And in this case, we did. So in July 2020, Olivia was brought to the defense expert with her mother for a CME. And that expert was Dr. Yoav Barnavan. He is a plastic surgeon. He did an in-person examination of Olivia in July 2020, so 3 years before trial, and wrote a report. That report was favorable for us, or so we felt. It said pretty much in black and white, she has a scar. It's consistent with the history reported of a hot nugget. It's permanent. And if anything can ever help this scar even just a little bit, it's going to be a future surgery. Well, that's pretty favorable for a plaintiff because that's the defense expert, meaning the best expert they could find says, we agree she's burned, it's permanent, and all that. So we didn't depose Dr. Barnavan or any of that. We get closer to trial, phase 2 of the trial, and all of a sudden, literally a few days before we're about to start, the defense files a motion. They want to request a second CME, the same doctor. The law begins to change here. So whereas in order to get one CME, the expectation is the defense has to show good cause. Now, in order to get a second CME, you need to show something more than good cause. And typically the appellate courts require some showing of a substantial change in circumstance. So think of another case. Let's say somebody gets in a car accident, they claim their back hurts. They get sent to a defense orthopedic surgeon who does a CME and reviews the medical records, talks to the plaintiff at that time, and comes to an opinion. And then a year later, the plaintiff has lumbar back surgery. Well, now the defense might go to court and say, hey, that surgery is a substantial change in the plaintiff's condition. I'd like my expert to reevaluate. And the courts will routinely do that if there's a substantial change. Here, there was no change. Olivia had not undergone any procedure. The scar was still there. And then a couple of days before phase 2, they claimed, no, it's really important that Dr. Barnavan see Olivia again. And when we asked why, and you read the motion, the thread that they were pulling was he needs updated photographs. Well, we were like, Judge, that doesn't make any sense. A, they asked us for updated photographs in October 2022. We gave them. And B, if that's really what they want, here's a couple of photographs. And we gave them, I think, photographs from 4 days before trial, phase 2 began. Here you go. And then, of course, we had a hearing on it, and then the defense started to pivot. No, it's not just for photographs. He needs to measure this and that. We fought it, and the judge ordered it. So they were entitled by court order to do the second CME, and they did. In Florida, we're allowed to go to the CME. We can bring court reporters or videographer to ensure that it's fair and what's going on is appropriate. We did that here. Well, when we got the video back, there were some comments made by Dr. Barnavan and some conduct that, in my belief as an advocate, was unprofessional, unbecoming, and uncomfortable, candidly. And I stepped back and we talked about it as a trial team. And one of the things we thought about was, hey, we're going to ask this jury in phase 2 to compensate Olivia for, among other things, being inconvenienced, being humiliated, embarrassed. How inconvenient is it for Olivia, this child, to be dragged to a stranger twice, not only once, but twice, to be examined in a sensitive area of her body, or it's just like the whole experience. Not that she should be embarrassed, but it can be embarrassing, right? There was testimony that she already doesn't like her own parents to look at it or touch it. So there is no law that I am aware of, no case that says that I'm aware of, that being subjected to a CME is not compensable, meaning you can't be compensated for it. If anything, to me, not only is there no law, but common sense supports that you should be able to recover for that. So in my opening statement in phase 2 of the trial, I started to preview that for the jury. We had the video of the second CME. I gave it to McDonald's. I didn't have to, but I did. And I said, hey, we intend to use this as an exhibit. They stipulated, meaning they formally agreed, yep, put this in evidence. The jury can see it. So once I know it's in evidence, I talk about it in an opening statement. But based on some of the comments that I made in an opening statement, for example, I said, I'm about to play a video of the second CME, something to the effect of, I want you to listen really carefully to Dr. Barnavan's words, what he says, and I want you to watch his hands with what he does. Why did I say listen to his words? Well, and this is in evidence, it's in the public record. He started the second CME by saying something to the effect of, oh, last time I saw you, you were a little girl, but now you're a more mature, attractive young lady. For an 8-year-old girl, I found that to be a very uncomfortable and quasi-unprofessional way to speak to her. So I told the jury to listen for that. The defense made a big deal about it. When the jury left the room, they even moved for a mistrial, suggesting the insinuation of unethical or criminal conduct. And I basically told the court, if that's the inference the defense is drawing, I mean, I don't know what to tell you, but the video is the video. I'm not bringing in something collateral from another case. I'm not just tossing out allegations with no basis. We have a video of it. So they stipulated it's in evidence. I have to comment on it. The judge disagreed with me, ultimately basically saying, well, I ordered them, that they were allowed to do it. And we tried to distinguish and say, Judge, there's a difference between entitlement to do something and whether or not it's compensable. Sure, they were entitled to do it over our objection, but it's still compulsory by its very name, meaning it's not voluntary, it's not comfortable. It's the doctor even said in the video, I don't want to embarrass you, meaning he anticipated it might be embarrassing, which is something we can get recovery for, but the judge disagreed. So we finished opening statements. He denied their motion for mistrial. Now we put on our case. So we called the mom, Felena Holmes, who has been courageous. I don't know. She has continued to show a tremendous amount of strength and fortitude because it's not easy. She gets dragged in the media a lot, especially after phase one, because she's the one in the drive-through video. But to her credit, she's kind of done a really good job of not paying attention to that stuff and focusing on her daughter's best interest. So she gets called up, and we had Keela do the direct examination. Now, Keela, not to put all her business out there, but I think like from a context standpoint, we got to give credit where it's due. Keela recently relocated. She used to live locally, much closer to Broward County. She's since moved. She traveled all the way back, several hours of a drive, basically 8.5 months pregnant. Keela is a phenomenal trial lawyer, but anybody who is anticipating the birth of their first child obviously has other things going on. She really wanted to try the case. We really wanted her to be a part of it, and she made a tremendous sacrifice to come down. So one of the witnesses that she handled was the mom, and I thought her direct examination of Miss Holmes was fantastic because we were never going to have Olivia testify in this case. We couldn't. And John, maybe you can talk about this. I don't think we've ever tried a case, correct me if I'm wrong, a personal injury case where the plaintiff didn't testify. And there's good reason for that. If it's money damages for the plaintiff, jurors want to hear from the plaintiff. Hey, tell us in your own words, how has this affected you? How do you feel? We couldn't do that here. And maybe you can elaborate a little bit more on Olivia's condition, the stipulation that was read, and how Keela was able to have the mom be the voice for Olivia.
Yeah. I mean, look, one of the things about like pain and suffering and those non-economic damages, I mean, you can hear and have individuals around them talk about what they're going through and what they're talking about and what they see. And that's kind of all we had in this case. But a lot of times jurors want to hear from the victim, not to get up there and say that, that I'm complaining or that she's like, giving up, I can't do all these things, but someone that, is vibrant, is fighting back, is trying to get through it, trying to continue on in their life, doing all of those things, but they can't. Like it's like an anchor tied to their waist, holding them back in the life that they should be living. And you can share that with the jury through the individual. In this case, notwithstanding the fact that my client was a minor at 4 years old at the time of this incident started, but she's 8 now, and she has. There was a stipulation read. It's into the record that she has an autism spectrum disorder diagnosis, and because of that, and a combination with her age, she has difficulty communicating in certain settings, so she was not going to be testifying. Now, that's fine. I mean, we got to live in what we have, so what we did was try to explain it through the mom and through the dad. Problem is, and the defense stipulated too, but then they kind of really tried to capitalize on it, right? They said, oh, she's not going to counseling. So because she's not going to counseling, that means her emotional distress isn't real. And it's like, I don't know. I mean, just because I don't go talk to somebody doesn't mean I can't be sad. And, but that's what they try to say. I was like, but she's literally going to speech therapists. Like, that's what she's doing to try to better her, her academic component of the school she goes to. So they try to say that. They also try to say, well, they suggested and it's in the medical record, that the day of this incident happened, when she just got scalded, that she was screaming for an hour, that she went to the hospital, said she has a 0 out of 10 pain, and that she was happy and gleeful, whatever the record said. And it's like, she can't even, like, she's not communicating. Like, she's not saying what's happening, and everybody's like, oh, she's 0 out of 10 pain. She looks at the faces in this young child. So they tried to really use that and then say, oh, well, it's not, there's no complaints in the records, it's not her. And what they did say, and they said this again in closing arguments, is that, in one of the records, it was Dr. Stern, and it says that, this is not bothering the child. Well, she's 4, right? I don't think 4-year-olds, they're vain or, but now she's 8, and through mom was saying, like, I don't like it, I don't want it, I want it gone. She's thought, aversion to being touched, aversion to, people looking at it, bathing suits, like when she's being bathed, clothes putting on. I mean, to the point that, when she was initially happened, she was potty trained, but she was, she was waiting and would wet herself because she didn't want to go through the hassle of actually going to the bathroom, because she'd have to take her underwear off and do all those kind of things and be touched, which she didn't want to have happen. So that's real. And they suggested that everything was just her mom, because it says that Olivia's not bothered by the scar. Her mom wants it to be checked out. And it's like, she's 4.
It was one of those, like, damned if you do, damned if you
Right.
don't for Miss Holmes. And that's why I'm so proud of her, because had Miss Holmes done nothing for her daughter, putting aside your personal feelings on parenting, had she seen, here's my daughter, she's disfigured, I brought her to the ER, they basically said there's nothing we could do. And had she never gone anywhere else and we go to trial, the defense would be like, how is this a big deal? She went to one ER visit and never saw another doctor.
Correct.
But mom didn't stop there. She brought her to a pediatrician, as the ER said she should follow up to. Pediatrician says there's really nothing more we can do. Mom, unsatisfied with that for her daughter, brings her to a dermatologist that she knows. Dermatologist says, here's all these different modalities that maybe we could do, steroid injections, laser therapy, but mom doesn't subject her 4-year-old daughter to that. Unsatisfied, hoping that maybe there's something else that no one has told her yet that can help her daughter, goes to Dr. Stern, who John talked about, a pediatric plastic surgeon. He reconfirms what the dermatologist said. There's all these different modalities, but he says in his own records, don't do any of them. You're not going to miss the boat. They'd be super frightening. They're basically painful in and of their own right. Let's wait till Olivia gets older. So, you had all these medical records saying don't do anything. And then the defense basically flipped it and tried to say, well, there's no medical records that say she did anything, or there's no medical records that say she's complaining. It's like, isn't bringing your child to specialist after specialist after specialist after specialist, isn't that evidence that suggests something was bothering Olivia? And I think this is a really good opportunity to stop and pivot for a minute. Not only was Miss Holmes our first witness in this phase, and as I mentioned earlier, Miss Holmes has kind of been the lightning rod in the court of public opinion, people trying to assign blame to her, even though that was never an issue, or just commenting on her parenting, which I find really obnoxious, candidly. But nevertheless, she perseveres. Here's what the defense did in this case. Under Florida law, the defense knew, and we told the court, we asked for a special jury instruction, the parents were never going to get the money. So whatever the jury decided to award Olivia, there was never really a scenario where the parents standed to profit a nickel. The defense knew that. So we said, Judge, the jury doesn't know that. And if you go through the media comments, you'll see everybody believes that the parents are driving this litigation for their own personal gain. And I know the defense even knows that's never going to happen under Florida law. The judge agreed with us and basically said your proposed jury instruction, or something similar to what you're proposing, can be read, because this jury should not be distracted and saying, well, I know the greater weight of the evidence supports a high verdict, but I'm not going to give it because I don't want the mom to recover money. Miss Holmes was never going to get money. Now, go back to Miss Holmes testifying in this trial. The defense, one of the defense lawyers, the one who cross-examined her, Jennifer Miller, she elicited some responses that made it suggest, and then later in closing argument, which we'll get to shortly, that this was really the mom doing this, still pushing this. Again, never said it explicitly, or maybe she did in closing, but it was always there, just beneath the surface, the suggestion to this jury that despite the jury instruction that tells you under Florida law the mom and dad stand to gain nothing, surely they think they're going to get something, that's why they're pushing it, which is just a really fancy lawyerly way of saying the mom is lying, manufacturing, fabricating all of these stories about Olivia struggling with her scar and self-image for money. And I know the defense has a job to do, and the defense in any case is entitled to put on a defense, but I don't have to like it. I don't have to agree with it. And more importantly, I think here for our discussion today, I think it was a strategic miscalculation. Had the judge not instructed the jury that the parents had no financial interest in the outcome no matter what, it would have been a big error. and I think it entitled us to a new trial. But once he did instruct them that, I don't think I think the defense should have pivoted. They should have put that aside, because we don't know. We didn't talk to the jurors, but after sitting through the trial, I'm there and I'm trying to think, put my juror hat on and think how I deliberate and vote. I found it to be offensive that while the judge is telling me under Florida law, mom will never get a nickel, here is Jennifer Miller and the rest of the defense insinuating that the mom is fabricating all these stories for financial gain. So I was kind of bothered by that.
Yeah, I mean, but that's every case, man. I mean, everybody's, if you were wronged by the negligence of a corporation, you're just out for money. I'm like, how about this? Companies invent a time machine that I can go back in time where your wrongdoing and your negligence doesn't harm my body. If you do that, then they will never have to pay money, and we got these fly-by-night like legal minds that are on TikTok and Instagram and social media, and they comment under and act like they know what they are. They're armchair lawyers, that they know what without any idea what the evidence was. And in fact, I was talking to one and I commented, she was like, well, how would you know? I was like, I was the lawyer on the case. Well, yeah, I don't really care what you say. That still doesn't make sense. I was like, okay, and what I wanted to say, and maybe I'll say it here, is like, you can't fix stupid. Okay, if you want to be stupid and you want to be in your mind, you want to believe whatever you want to believe, that's fine. If you want to believe Fern Gully was a real place, that's fine. Okay, I'm not going to change your mind. The reality is we took a case against all odds, right? Constantly told we're going to lose, we're going to lose, we're going to lose. And what did we do? We won twice. And everyone out there saying, oh, it's bullshit, then how did it come it didn't get thrown out? How come the defense didn't win? If it's such common sense that everyone thinks it is, how come the jury disagreed with every?
Yeah, we don't decide. Jurors do. The jurors are people from the community.
Right.
So it's not a situation where the judge found us more persuasive.
I think we were told it was a $500 case, and we got $800,000. A little bit off, a couple decimal points, maybe 1,000 decimal points, but that's the reality.
I think Miss Holmes did a really,
you know how courageous that is for her to do this.
But it's like so hard, because no matter how legitimate the case, no matter how good natured a parent is, Miss Holmes is not some professional witness.
No.
Mr. Caravallo's he's not a professional. He's not an expert. They don't do this. Public speaking is the number one fear in the world. And I think you saw from Miss Holmes and her ex-husband, public speaking is not exactly their strength. And I mean that as a compliment. They're normal people. They don't walk into courtrooms and have, 100 sets of eyes staring at them, millions worldwide, hanging on every word and move they make. And nevertheless, when they testified, but especially Miss Holmes, she came across as the genuine article, as what she and who she is, a legitimately concerned, loving mother of a really wonderful child who has all these wonderful things going for her, but this one thing happened and now it's a hang up for life. I think the jury saw the authenticity there. Again, that's not a lawyer speaking. I mean, what I'm telling you now as a lawyer, it's my words, but when you were there, it was Miss Holmes and the jury. And I think the jury found she was very credible, and I think they had every reason to. So the next witness we called, just to move forward in time, was Dr. Joshua Carson. John discussed it. This was an expert we retained. He wasn't a treating physician. And we said, look, you are a double board certified, he's certified in, trauma, critical care. All he does is handle burn trauma patients. That's who we wanted to evaluate the case. So we sent him all the photographs, the short videos of Olivia when it happened, the medical records, the depositions, everything. We said, look, here's all the evidence in the case, good, bad, or otherwise. Take a look at it, and what are your opinions? So coming into trial, we knew what his opinions were. The defense had deposed him, and his opinions are pretty straightforward, that Olivia was permanently scarred, that the scar was consistent with what was reported, meaning a hot chicken nugget, that the scar was at least second degree with probably some third degree components. I'm going to talk about that more in a moment. But that all of the ways she could potentially manage the scar in the future, none of them would make it go away. Meaning, even with a scar revision surgery, you're still left with a scar. He flew down from Illinois. He came into court. John talked about his demeanor. I find him to be a very likable person. Obviously, I think the jury's verdict reflects the fact that they liked not only what he had to say, but how he said it. He too was very authentic. He's not one of these hired guns where he just comes in and says whatever he think will be favorable to us at all costs. He comes in and he gives his honest assessment, and he backs it up with peer-reviewed stuff. So he came in and he talked about that. He also shed some light and expounded a little bit on how there's no correlation in the medical literature between size of a scar and the amount of emotional trauma that someone's left with. He gave examples. He's treated thousands and thousands of burn patients. You might see someone with a third of their body disfigured by burns, and they can somehow move past it once treatment is done. But then you have someone with a very small scar, relatively speaking, and it's like the biggest thing in the world to them. And John, I think, referred to that, like to Olivia, this is like a mountain. But Dr. Carson did a really good job testifying. John, maybe you can elaborate a little bit when the defense got up and tried to cross-examine him, some of the, I'm going to say shenanigans, maybe hoopla is the better word, that they tried to pull, and how Dr. Carson dealt with it.
Yeah, I mean, so one of the things was, like, a lot of everyone said, like, it's a second-degree burn, but really not just, they said it's a second-degree burn, if not a third-degree burn. And that was the testimony of the treating plastic surgeon, and that was the testimony of Dr. Carson. He said, like, look, there's portions of it that appear to be third-degree burn, right? So, and second-degree burn, deep tissue second-degree burn, is not a little burn. It's not like a nothing, and everyone's like, oh, it's only second-degree, like, But, and so what he said was, he's like, look, it was a second degree, and there were levels of third degree burn. But what he said in his deposition was, he was like, look, if I had to pick the two, I would say second degree or deep tissue second degree burn versus a third degree, because the only way you can know about the third degree is you have to, like, examine it down through the skin to see if it hit through every layer of skin. That's the only real way to know if it's a third degree burn. And they tried to impeach him with that, and he said, no. Read 3 lines up, which they did. He told him it's possible it's a third degree burn, and they tried to say, you didn't say it was. And what he had said was, if I have to pick the two, whether it be second degree or third degree, I'm going to say it's a deep second degree burn, because no one can know that. And even the defense expert said, you can't know. No one knows really if it's a third degree burn, so which means it could be, and so everyone's saying, like, it's no big deal. We're talking about third degree burns from a food product that everyone says, well, it's the parent's fault, and it just, boils my blood to the temperature of that hot chicken nugget, when I hear things like that. And so he did a great job explaining the healing process of, like, when you have a burn, like, the top level will heal, but the underlying, it hasn't healed. And, I really tried to focus on that in closing argument, him only being the only true expert, because they tried to say, like, oh, it healed in 3 weeks, it's no big deal. And that's not the case. I mean, there were photographs that showed 4 months later she still has scabbing in the central area, which ended up being the raised portion of her scar that she has permanently. Like, this little girl's disfigured for the rest of her life, and people want to be dismissive. And it's interesting. Everyone that calls it frivolous and says it's bullshit, until it happens to their kid, then they're gonna be like, yeah, it's not frivolous, and they, that's what we commonly see. Everyone who is a proponent to change the way lawsuits work, or be on board with corporations. Like, I never understood why everyone they're like, it's all about personal responsibility. Well, what about the corporate responsibility? The people that take your money, make billions of dollars a year, and they do it without any regard for safety, and then everyone wants to just give them a free pass. Like, under the law, according to this United States Supreme Court, corporations are people too. So they have personal responsibility. In Wisconsin, corporations can go to jail. So let's not act like these are holier-than-thou businesses, like everyone's just taking advantage of them. When have you heard about cases like this? You don't.
Well, and this is the key, I think, too. This talking point about taking advantage of the legal system, taking advantage of a big corporation. Nobody can do that when you go to trial, because it's not up to the lawyers. It is literally up to people from the community who, presumptively know nothing about the case, but hear everything about the case and then decide what's fair. So a jury verdict is not a lawyer saying, ha, we win. Right. It's the community saying the corporation did wrong, or the community should be, the corporation should be responsible.
Right. We didn't say that. Those jurors agreed with us.
And I see a lot of other comments too. Let me just say this. People see the photographs of the burns because they're out there. It's a public proceeding and the media covers it. They see photographs of the burns, and what the number one comment I see is some variation of impossible to have been caused by a nugget. Impossible. Possible. Keep this in mind, folks. The jury wasn't asked to decide what caused it. Why? McDonald's and Upchurch stipulated, they formally agreed, admitted that her scar, those burn photos, they were caused by a nugget that was sold in a Happy Meal. It was never even disputed. So all the people out there saying it's manufactured by the mom burned her own child, or something else must have done that, it's impossible. It's so far from that, it's the opposite end of the spectrum. It was admitted by McDonald's. Right. Despite all the fight they put up, that was never a point of contention.
Yeah, and that, and even with that, people are like, I still don't believe it. I was like, well, guess what? I don't give a shit what you believe. I really don't. I mean, I'm not in the business of caring what people believe. I don't care what you think about me. I don't care what you think about my firm. I don't care what you think about our clients. Like the reality is a juror, was impaneled under what the Constitution provides to resolve a dispute between two individuals, and they selected what the greater weight, the more persuasive force of the evidence showed, which was McDonald was responsible, Upchurch was responsible for the harm that they caused to this little girl, and the tune of that in her damages in the past and into the future was $800,000. And that's the only truth that matters. And, ultimately, if there's a post-trial motions and for whatever reason, if a new trial is granted, we will be back on this podcast with an update of how we will go to trial again and we will get more. And you'll hear
I believe that would be
and
the
I
case.
believe we'll hear it here first, and we'll do it again. And if it comes back again, we'll do it again. And we won't sleep or rest until justice is had. Especially for these.
And these are, by the way, folks, these are public proceedings, and we had court reporters. Genie Reporting is the agency that covered it. A lot of people are like, "Oh, who's spinning what?" For the people who are totally invested in this story and really want to get the truth. I mean, you're never gonna get from a transcript body language and intonation of voice, but you can order transcripts and read them verbatim of every word that was said by everyone in the courtroom, witnesses and lawyers and judges alike, and you can draw your own conclusions. And I think that would change a lot of minds.
You can watch closing arguments. You can watch closing arguments from. You can watch my closing arguments. You can watch Miss Miller's closing arguments, and you can watch Miss Smith in rebuttal and see what happens and see what you think about hearing about the case, seeing the photos, seeing the evidence, watching the PowerPoints, and see what you think. And if the jury came to the right decision. So, and we think
to just top off, or to summarize rather, the other witnesses, all of them are important, but I think it's interesting how it unfolded. So after Dr. Carson, Olivia's dad testified, Mr. Caravallo, another very soft-spoken gentleman, but John did a really good job with that direct examination, eliciting what I felt was two really important points. One, he received a phone call from his then wife, Olivia's mom, Miss Holmes, like within minutes after the burn actually happened. And all he could hear was like blood curdling screams on the other end. He couldn't even tell if it was his son or daughter. His son was 5, Olivia was 4 at the time. He just knew it was one of his children screaming in a way that he had never heard before. When mom brings kids home and he meets them there and he sees what's going on, I mean, those are screams he'll never forget. And mom and dad both testified Olivia was screaming like that for hours. Or for a really long period of time, and there was nothing they could really do to stop it. So I thought his testimony was really important on that point, the immediacy after the burn, how much pain and suffering she endured. And then the second part of it was, I thought the defense kind of stepped it in here. They were like, oh, well, Olivia's 8 now, and some of the testimony that you just said was that, when you bathe her, she doesn't like you to go in that area because, it's like an issue for her. Doesn't she bathe herself at 8 years old? And he's like, no, she still doesn't, which means, this burn is unique. Every plaintiff's case is unique to them. So like this burn, even all things being equal on somebody else, maybe would not affect them as much, or maybe even more. But to Olivia, with all she's going on in her life, she calls it her nugget. She tells her parents she wants it gone. It is a big point for them. There was testimony about, they would decide, like, do we even want to go out of the house today? Because we're going to have to prepare Olivia. We have to put on your car seat, or if I'm going grocery shopping, I have to put you in the front of the cart, and or we're going to the pool. People might see this. So the parents did a really good job, I think, of bringing to life Olivia's voice, and the jury heard her through them. After we rested, I want to talk a little bit about some strategy stuff that maybe the lawyers can appreciate. So before phase 2 of trial began, the defense asked to take a deposition of Olivia's older brother. He's only a year older. I'll spare his name for purposes of this podcast. And we said, okay. So they took his deposition. They must have felt like her brother said something favorable, because before trial, they gave us notice of their intention. They wanted to read his transcript to the jury. No, not a thing. Under Rule 1.330 of the Florida Rules of Civil Procedure, it specifies how you can use the deposition of a witness. And basically, unless they're unavailable or unless they're an expert, you have to bring a witness in court. And for obvious reasons, it would be a terrible system if all you could do is just read statements from people. So we told the court, if they want his testimony, they've got to call him live. We'll bring him. Just tell us when you want him here. And lo and behold, when push came to shove and McDonald's had to decide, am I going to drag in a 9-year-old child to basically testify against his sister. Not that against is my word, not theirs, but I think their hope was he would say something favorable for them, not his sister. They decided not to do it. And I think that was a good decision by them. It wouldn't have looked good in my opinion. Then there's an issue of treating providers. Before trial, the defense told us we're going to call Olivia's pediatrician. We're going to call Dr. Stern, the plastic surgeon she saw. We're going to call the dermatologist, all these people. During calls, I was led to believe this was a big deal. They were subpoenaing all these doctors. They're going to drag them out of their practice. I think the idea that they were trying to convey to us was there's unfavorable things in these medical records, and we're going to have these doctors come testify. We said, come on, let's go. We're done. We arrested 3 witnesses. We're done. Case is yours right here on day 1. They didn't call any of the treaters.
Yeah, they just called their one expert. That's it,
Yeah, so it turned out to be a bluff by them. But those records came in evidence. So then we go to closing argument. I want to talk a little bit about that. The media did report the amount of money that we asked for, $15 million. John did the first closing, which is the most substantive part. I want John in a moment to explain more or less the method that we gave the jury, like to support that number. But there's more to a closing argument than just the ask, the amount of money you're giving, asking a jury to return. Closing argument is supposed to summarize all of the evidence that the jury has now heard and seen and explain, but through advocacy, why it supports the claims here. So John did a really good job in the first closing argument, which he had 45 minutes to give, of explaining to the jury first all of the categories under Florida law that Olivia was entitled to recover from. Like you hear a word pain and you immediately assume physical pain, and that's natural. And sure, physical pain is something you can be compensated for, but isn't there also emotional pain, right? Those are 2 different concepts. The defense really tried to cabin those terms in very literal sense and say, there's no more physical pain. John got up there and said, we agree. The scar is healed. It's still there, but it is healed now. She shouldn't be in any physical pain. Don't give her money for that, right? Don't give her money for that. And I think we score some credibility points by being credible and honest when we review the evidence. But does that mean that she doesn't have emotional pain? This girl's 8 years old, doesn't want her own parents to see it, touch it. She insists she wants it gone. The mom testified through emotional testimony. She doesn't even know how to yet explain to Olivia that there's really nothing that will ever take it away. I don't look forward to that day for Ms. Holmes to have to explain it. But John, maybe you could walk the listeners out there. We did ask for 15 million, but how did we get to that number?
So, Jordan got up an opening statement and basically said like 5 million for the past and 10 million for the future. And, the difficulties with the past pain and suffering is because generally what I like to do is a per diem argument of like, we take all of those separate categories and you look at the evidence and say, well, how am I going to do this on for the next 75 years, right? In her case, it was 73.8 years.
Meaning her future life expectancy.
Right. So it's a difficult proposition. So what you do is this. I said, forget the time. Forget 73.8 years. Let's talk about 1 hour, right? What's the simplest unit of time and measurement for something like, everybody gets paid by the hour or, waiting for an hour, whatever. And I say, and you go through each one of these categories, right? Pain and suffering, physical, emotional, mental anguish, inconvenience, disfigurement, and loss of enjoyment of life. Those were the categories we had in this particular case. And I said, and go around and go through each category, because she has each category of damages, and I talked a little bit about each category of damages, and I say assign a value between $1 and $10 an hour, and then you ultimately come to a number. And that's what I did for the future damages. The number, obviously, the highest one would be disfigurement because she's got the permanent scarring. And I said I ended up at a number that was $25 an hour. And I said, and then once you guys say this is what's fair and reasonable, that if we took another person out of the community, we brought them in here, and we said, we're going to subject you to all of this and scar you for the rest of your life. We'll give you $25 an hour to deal And when you simply take that number and then you do simple math, you multiply it out, right? And I don't do 24 hours in the day. I do 16 hours in the day because 8 hours you're sleeping, so I don't think you need to recover you may hear what people have. It's disruptive of sleep. But in this particular case, we took it out. So it was $25 an hour times 16 hours a day times 365 days in a year times 73.8 years. That came about to about 10.774, I think 600 was the number, millions of dollars. So but when you think about it, it's only $25 an hour. But it just seems so long because it's 73.8 years. And that's what I kind of stressed to the jury is like, we never get to come back. We don't get to check on them in 5 years or 10 years or 20 years or 40 years. And then I also say, think about the value of $1. Today, It's not going to be the same it is in the year 2090, which the verdict still had to be there for. And I said, a good way to know that, use your common sense, go back 73 years to 1950. What was the value of a dollar back then compared to today? Obviously, significantly different. And so those are the kind of things you tell the jury. And, we present that. And then, I gave them a little preview of what the defense's story. I call them defendant's story. Right? What's their story? And they have a variety of stories. And what they did is they got up and literally did the stories that I had previewed the evidence for them of why that was not the case. And so I think that's a good way to kind of undercut what they do, and then they get up and say exactly what you say they're going to say, and after you've told them why it's wrong. So, and
also, let me just say this too: we have to give recommendations to jurors in closing argument. We can't insist on anything. We just say, here's all the evidence, and here's what we think the evidence supports. And in this case, it was 15 million. We don't just leave it out there, as John just explained. We show them how we get there. Remember, growing up in grade school, show your math, show your work. We do that for them. It's just a recommendation, though. I love the fact that the media took an interest in this case. I think it's an important thing in any case. Courts are public proceedings, and I think it would be more beneficial for the country if more trials were covered, not just those that can be sensationalized. And media has a job to do, and part of it is to get people to read or listen or watch whatever they're publishing. And I understand that. But when you see headlines like asked for 15 million, it could have just as easily been reported plaintiff asked for $25 an hour. And I think if the headlines read that, very few eyebrows would have been raised, because that's ultimately what we asked for. Yes, when you do the math, the final number is 15, but it was really just $25 an hour for the future. And so it's just like, it's important, I think, to keep in mind, that things are put in context however they need to. People have their own personal biases, agendas, whatever, but those are the facts. You can read the transcript. That's what we asked for. And for those out there saying this case was worthless, meaning worth nothing, McDonald's in their closing argument said you could and basically should give Olivia $100,000 for the past 4 years, the past pain and suffering, past non-economic damages. But then they said she's fine. So there really shouldn't be anything for the future. Then they started to equivocate, and I thought strategically this was a misstep. This is just my personal, take on it as an advocate, looking back now at the benefit of hindsight. I think it's hard to tell a jury she's entitled to nothing in the future, but then say, but maybe, if anything, $4,700 for that scar revision surgery that maybe she'll get. But, and then they said and then maybe another 50K on top. And all of a sudden it went from no more than 100 to, maybe 100 to 156,000. It became, in my opinion, less convincing the more the defense kept suggesting different numbers. Mm-hmm. I want to say two things about that. One, if you're out there and you're saying this case is worthless, McDonald's conceded in closing argument, essentially, that the case was at least worth $100,000. Okay. Jury came back 8x that. And the second thing to consider is it wasn't worthless because all of the evidence was basically undisputed. This scar was never going away. So if under Florida law, disfigurement, which is just a fancy way of saying, it's to cover scarring, if disfigurement is recoverable under Florida law and it's undisputed that she's disfigured for life, she's got to be entitled to something. And so I think the jury did its best to consider all of the evidence, the recommendations from us, the recommendations from the defense. And the last thing I'll say is we are advocates. Our job is to keep our client's best interests in mind. And in a case like this, to recover the full and fair value of justice. Did we recover every penny of what we asked for? No. Does any plaintiff lawyer routinely get jury verdicts exactly what they asked for? No. Often jury verdicts, I think, beyond a reflection of what the actual evidence in law is, they are also a reflection of human nature, which is to find compromise. Lawsuits are a dispute between two sides. Here, one plaintiff versus two defendants, but still it's two sides to a dispute. And I think it's totally natural, and I find it to be very commonplace that the jury, even when the plaintiff wins, doesn't give what the plaintiff recommends, but also doesn't do what the defense recommends. They come somewhere in between the two. And that's what they did here. And I was asked after the trial, I am totally satisfied with this. In any case that I go in, all I want is for the jury to listen, be fair. I want them to consider all the evidence, all the arguments, really apply the law, nothing else, set aside your sympathies, and tell me what the case is worth. And the good news here is the case was worth $800,000 when McDonald said it would never win. And if we did, it was worth far, far less. And the fact that the most important thing I take away here is the fact that McDonald's was basically of the position and belief at trial that future damages don't exist, pain, suffering, emotional trauma, loss of the ability to enjoy life. Their position was essentially that's nonsense. There's nothing there. The jury gave $400,000 for future damages and $400,000 in the past, which is another way of saying they gave equal amounts both past and future, which to me reflects they totally rejected the notion that McDonald's was suggesting, which is that Olivia had no future damages. They showed that the past was just as important as the future, and that's why I say it's a totally just verdict. And we don't know what McDonald's is going to do, motions for new trial, appeals. We don't know. I'm sure they'll pursue all of that, and we'll fight it out in the appellate courts. But for present purposes, I feel really good about it because it was a very challenging case legally. It took a long time to get there. And, these are the types of people I want to fight for. These are the types of people our firm exists to help serve. Families like this, a child like this. My hope is that one day, whatever it is, 10 years, 15 years from now, whenever it is, that Olivia has enough wherewithal that maybe she'll look back at her parents and it's like, thank them. Thank you for having the strength to pursue this and not sweep it under the rug because you're shy or don't like public speaking or don't want to be dragged in public, in media. But if nothing else, we have now made a difference. We have shifted the course of the future of Olivia's life. We have helped just a little bit right a wrong by two big corporations, very powerful corporations. And I'm proud that we stood up to them toe to toe, two separate trials, and two separate juries unanimously agreed with our side. And I'm grateful to Keela for trying this case with us. I'm grateful to House and Lewis and everybody else in our firm, even the non-lawyers in our firm who work with us. Their opinions are invaluable. And, we work this case up for years and we get opinions from everybody. It's a group effort. And this is a really big firm win for us. And I'm proud to be a part of it.
Yeah, it was a lot of fun. It's always good to win, and what I don't think people realize is they always say like, when the plaintiffs' personal injury lawyers, they take a lot of money. I was like, do you understand that we don't get paid unless we win? What other person, like maybe with sales, if you don't sell, you don't get paid. But if
so saying about put your money where your mouth
right.
is,
Defense lawyers, they get paid to fight. We get paid to win. And I think that's the difference. And so it takes a bit of courage for the plaintiffs. It takes a courage for the lawyers. We invest our time, energy, and money with no guarantee of return. And I think to suggest like, oh, we're in it for the money, I'm in it to fight for people. And if we lose, we lose. But, I'm going down swinging. And this was that case. And fortunately for us, we were able to pull out a win, for our client, who's, like Jordan said, we're going to change the course for life for the better. And, at the end of the day, when I lay my head on the pillow at night, that's the kind of things that keeps me motivated to keep going. And all the public scorn and scrutiny that I may face, so what? Ain't going to change my life. So,
And look, to the colleagues out there, and I say colleagues, it's a broad term, to the people out there, lawyers and non-lawyers alike, who follow the story or are catching up to the story. For those of you that have reached out to us privately to share their insights, many of which is overwhelmingly positive, I want to thank you on behalf of the whole firm. It means a lot. We fought really hard for a really long time with no prospects of actual recovery. In fact, we were told we would lose with certainty. And there's a lot of lawyers out there reaching out saying how excited they are because they have to be self-critical and say, man, I might not even have taken that case. And if I did, I probably would have tried to settle it for a fraction of what you got. And I never would have tried it. And if I did try it, I never would have asked for this. And so I feel good that if nothing else, maybe we can motivate, inspire, or be a sounding board for our colleagues out there who might have similar cases or even just other challenging cases, polarizing cases, and show them like sometimes you've got to risk, you've got to be willing to roll the dice for your clients.
Absolutely.
It can't always be a negotiated settlement. Some cases have to be tried in courtrooms. This was one of those cases. We did it twice. We won twice. If we have to do it a third time, which I don't think we will, we'll do that too. We don't give up for our clients, but for everyone out there, I just want to thank you for listening today. If you're watching live, especially, if you have some comments or you're watching it later, feel free to drop some comments. Justin's really good about forwarding us those, and we can always either do another show to explain them or reach out to you. We really want to. This is clearly a story that's captured the attention of the country and even beyond America. And for those people out there who have more than just sarcastic comments to make, but have genuine intrigue, I want to be here to help educate you about the case. And it's a matter of public record, so we have nothing nothing to hide. So thanks for joining us. Thanks for tuning in. Stay tuned for more content as we continue to release new episodes of On Justice Podcast. And if this is your first episode that you're watching, feel free to go back on Spotify, YouTube, or any other platform that you enjoy podcasts, because we've been doing this now, I believe, over a year, and we cover a variety of topics in different cases.
And we also have our hot soup case that was another similar food-borne or hot food product case that we handled as well. Had a full podcast on it, so check it out. I mean, it's not really a niche for us, but it's something that we have, like any case. If we're going to bring it, we're going to find out everything we can about it and find a way to win and really to be over-prepared and to outwork the other side, which is what we do in every case. So thanks for tuning in, everyone, for this episode. We'll see you guys soon, and hopefully, next time come around.
All right, give me a second.